Hello, my name is Alan Rycroft and I want to introduce Work Law's January newsletter. Since our last newsletter, there have been 7 important decisions from the Constitutional Court, the Supreme Court of Appeals and the Labour Appeal Court. And instead of our normal formula of having an article in 3 cases, this month we are going to tackle the 7 important decisions. I'm going to spend 2 minutes highlighting just 3 of these judgments. In a judgment from the Supreme Court of Appeal, the issue was whether a picket declared by a trade union fell under the Regulation of Gatherings Act. Now this is a serious question because under the Gatherings Act, a person can claim for damages suffered. The employer in this case wanted to claim for damages caused by violent picketers. The Supreme Court of Appeals, however, said that Section 11 of the Gatherings Act does not apply to claims for loss attributable to conduct committed during the course of a picket authorised in terms of the LRA. The reason, they said, is that the LRA provides for the consequences of non-compliant conduct. In another case, the issue was whether an employer can dismiss a striker in an unprotected strike, even though the striker complies with the ultimatum. The Labour Appeal Court held that where illegally striking employees obey an ultimatum and return to work within the stipulated time, the employer will not be entitled to dismiss them for such breach. An ultimatum by the employer is a waiver of the right to dismiss for the period of its duration, the court said. Now, we've got concerns about this judgment because it may lead to repeated unprocedural strike action by employees with no threat of dismissal, provided that on each occasion they comply with the required ultimatum. We think that the precise wording of the ultimatum needs to recognise that some employees might be on a final written warning and the consequences might not necessarily be no action at all. In the third case, the issue is whether it is unfair discrimination to put a waiting period of 2 years on a salary increase for a new employee. The Labour Appeal Court said that whatever the possible adverse consequences caused by a pay progression system, these do not constitute discrimination of a kind that could justify a claim in terms of Section 6 of the Employment Equity Act. So that's just 3 of the cases, and you'll have to read the remaining 4 in the newsletter, which I hope you'll find stimulating.